So what I thought we might do this morning was take a look at some of the three of the recent Supreme Court decisions from 2022 that are currently setting the tone for the court in the area of religious liberty. And that's important because it sets a tone for the appellate courts to a certain degree. Although you're going to find a lot of contradictions in the material that I present today, because it's like a river that's got two rivers coming into it, and it's swirling around. So we have Trump-era judges, we have the new Biden-era judges coming in, we have a fairly conservative Supreme Court now that is setting a good tone and is trying to bring some uniformity to the circuits. But historically, if you look at the federal court system, you start with the trial courts. Those are typically in your state and district. And if they make a mistake, or if somebody disagrees with their ruling, they can be ruled to a circuit court of appeals. And in the Ninth Circuit Court of Appeals, for example, covers California and the West Coast. And so if we have a problem, we go to that circuit. If we don't like what they did, we can appeal to the United States Supreme Court. And there are over 10,000 appeals a year. They're called a request for a grant of certiorari, but fewer than 1% of those are granted. So there's a lot of emphasis on understanding what goes on in the circuits and which circuit you're in, because that's your direct supervisor, if you will. The Supreme Court often takes cases where the circuits have reached opposite conclusions. And so sometimes they will let questions that are controversial go intentionally for years to see how the circuits are lining up on them, and then they'll come in and try to resolve the conflict between the circuits. It is. The district courts are your local courts. Like the Arizona district, for example, they're the ones that have juries. Federal Circuit Court, yeah, they're courts of appeal, like the Ninth Circuit, the Second Circuit. So, three great cases, and these are really stories, and that's kind of I thought we'd maybe have a little bit more of a. I've got pictures of these guys. We're gonna see what happens when you have to fight City Hall to fly a flag, when you have a question of trying to get school funding for a Christian school, but they say no, if you actually teach any Christianity, you can't have the money, but if you don't actually teach it, you can have it. Welcome to the state of Maine. The coach who kneels in prayer after the game, what happens to him when he gets fired? And so we'll look at how the courts have resolved these three questions and with real humans. We'll take a look at a pending case that the Alliance Defending Freedom is currently litigating now that involves a music teacher who got fired because the music teacher refused to use pronouns designated by the students that were inconsistent with their biological sex. And the backstory to that is absolutely fascinating when you see how to whack some of this stuff can get. And then I thought, for those of you who have been coming to these seminars over the years, we'll give you the rest of the story, as Paul Harvey used to say, on what happened to the Boy Scouts. It's been probably 3 or 4 years ago we did a class on the Boy Scouts, and that was before they filed bankruptcy. And now, what's the status of the Boy Scouts? We'll give you the rest of the story with Jack, the cake baker, who won the case at the United States Supreme Court and is now back in court over cake. Barronelle Stutzman was a florist from Washington who got involved in one of those social issues. And then there's a current case in Connecticut. We got a ruling on the 13th of February, just a couple of days ago, about female athletes who have gone to court to try to have the right to not compete against males who now think they're females. And when you look at the statistics and what's gone on in that case, you'll be something, I don't know, somewhere between shock, disgust, and I don't know. So all of our discussions in this area of the law originate with our Constitution and Bill of Rights. And there are two phrases that you will hear continually in these cases. One is called the Establishment Clause, and that grows out of the First Amendment to the Constitution in the Bill of Rights, and the language is, Congress shall make no law respecting the establishment of religion. If you think about that historically, the people who came to the United States leaving Europe were trying to get away from religious oppression, where the king had basically set up a church as a way of collecting taxes and controlling life. They were sick of it, and they said, so when we set up our country in the United States, we're keeping the government, the king in effect, out of our lives. So one of the first amendments was, Congress will make no law respecting the establishment of religion, meaning we can't be forced into a state church. Like King Henry had his own version of a church. In Sweden, for example, they had a state church, etc. So that's called the Establishment Clause, and many times you'll hear that reference to giving money to a Christian school violates the Establishment Clause. Well, does it really? And we'll look at that, how those arguments play out, because there is a sincere difference of opinion in the country about how that clause should be interpreted.
Why does it stop right there?
Well, I'm glad you asked that question. Oh, darn, I dropped the other slide. That's called the free exercise cases. And that's the ones that say, when we're focusing on establishing religions, then we're arguing about the Establishment Clause. But when we're talking about the exercise of religion, we're calling the Free Exercise Clause. So it's all about 6 words staying together, but you will hear references to the Establishment Clause versus the Free Exercise Clause.
The key is that it's not a complete sentence, it's a clause.
Correct, they're each clauses, or the free exercise thereof. So, to your point, Congress shall make no laws respecting the free exercise thereof. It does, and it's confusing, and in some of the cases, if you don't know what the shorthand of Establishment Clause means versus free exercise clause, it can get confusing. And thank you for shining the light on the confusion. So what happens when you want to fly a Christian flag in front of the courthouse, and the city of Boston says no? Well, in this case, it was an absolute textbook example of openly discriminating against the Christian religion. Well, the city of Boston for years had allowed one of their flagpoles out front to be used by a variety of organizations. In over 12 years, they had approved 50 different flags at 284 different ceremonies and had never once denied a request. Now, interestingly, in that the statistic doesn't tell us if any Christian organizations had ever applied before. But when Mr. Shurtleff, the director of Camp Constitution, asked to raise a flag that included a red cross on a blue field, the background, guess what happened? Nope, they said this could violate the Constitution's Establishment Clause, and they denied it. One denial in 12 years, and it's because you're a Christian. Now, you just have to look at that and say, this can't possibly be fair. So, the Supreme Court, when it finally wound its way up there, unanimously ruled that the city of Boston was out of bounds. And the logic behind these Supreme Court cases is important to look at if you're trying to take that rule and then apply it on to your own situation or to other fact patterns. So they said, government speech occurs if, but only if, a government purposefully expresses a message of its own through persons authorized to speak on its behalf, and doing so does not rely on a means that abridges private speech. So the issue here is, it becomes a violation of the Establishment Clause if the government is telling us how to worship. So, in a real common sense way, just flying that flag in front of the city hall tell everybody they got to be Christians. If it does, that violates the Establishment Clause. because now we're using government tax dollars to force Christianity on the heathens, right? So these, you can see the context of these questions becomes extremely important, because it's not hard, I suppose, to imagine a situation if every flagpole in the city of Boston had to fly a Christian flag, and they allowed no other flags to be flown. And not only that, it could only be Presbyterian flags. You couldn't fly a Baptist flag or a Lutheran flag. And that because the mayor of Boston decided everybody needed to be Presbyterians. Well, we'd have a constitutional issue, wouldn't we? But in this context, where they, for 12 years, allowed 274 different flags to fly, but not the Christian flag, it's clearly not government speech. I mean, they're letting all kinds of people fly flags out there. This is not a case of the government trying to force a flag down somebody's throat, right? So that's the idea. That's the kind of the common sense, quick analysis of the Scherfeld versus City of Boston case. So if you are running into a city administrator who grants all kinds of exceptions to other organizations, but specifically won't allow a Christian organization, you may very well have a violation of your constitutional rights. In the Justices Alito, Thomas, and Gorsuch wrote a concurring opinion. Remember, the entire court voted to strike Boston down. But is often the case, the justices don't agree on why they voted that way. So these guys wanted to take the time to explain why they voted that way, and they said, the real question in government speech cases is whether the government is speaking or is it regulating private expression. This wasn't the government announcing a principle, right, that y'all had to be Christians. And so Boston was just way out of line. Let me push the pause button now. Any questions about that establishment issue, the government speech issue, and kind of what that tells us about the tenor of the court? Because if you go back and look at decades ago, earlier speech cases, you would find some where they took a more harsh view of that because they were more worried about trying to rein in the government.
That case would have gone to a circuit court.
Yes, right. And they ruled in favor of Boston.
And correct me if I'm wrong, circuit court judges are appointed, is that right?
They're appointed by the president and approved by the United States Senate. And it's Trump, probably, I don't want to get into whether Trump's a good guy, a bad guy, or any guy at all, but the one thing he did that everybody agrees was great is he got a boatload of conservative justices appointed to the circuit courts of appeal and to the trial courts, and including Gorsuch, of course, and the other Supreme Court justice. Now, that's going to be one of the critical things to watch if you want to keep an eye on what your future looks like. Keep an eye on what happens at the Supreme Court and on those courts of appeals about how successful Biden is in getting new judges with his philosophy.
Court judges are appointed for life.
Yeah, as are the all the federal judges are basically. So the next case, this little cute family is the Carson family, and they lived in a state of Maine, which had imposed a, quote, non-sectarian requirement, meaning it couldn't have any religious overtones, for participating in the state's tuition assistance program. And they said Maine was interested in preventing public dollars from being put to religious uses. This kind of has a familiar ring, doesn't it? Because we've been watching cases argue about this now for several years. And this was the part, you almost can't make this up. They literally argued and said to those who applied, and then argued in front of the court, if the school is religious in name only, but doesn't actually practice religion by incorporating religion into the school curriculum, then we'll give you the money. So this tuition program, you could be a private school, you could apply, you could get tuition assistance. If you could be a private Christian school, as long as you don't teach any Christian principles, you can get the money. But if you're a private Christian school and you actually teach any religion, you can't get the money. Now, what was remarkable about the state of Maine, I'm going to do a little quick rabbit trail here. The Blaine Amendment, you'll sometimes hear references to that. That goes back to the 19th century, the 1800s, and I think it was Montana that started this. They were trying to keep the Catholics basically repressed. It was pretty anti-Catholic business. So they wouldn't let any money of any kind go to any Catholic school. And these Blaine Amendments wobbled along and eventually now have been effectively all overruled as being, you can't pick on the Catholics, you can't pick on the Christians, and as a matter of fact, you can't pick on any religion. And if you're funding schools, you got to be even-handed about it. So in 2017, the Supreme Court had held that in the Trinity Lutheran Church case, this was a great case, they had wanted to improve their playground. And so the state of Missouri was giving money out to private schools to fix up their playgrounds. And when Trinity Lutheran applied, they said, sorry, you're Christian, you can't fix your playground. What? I mean, so the Supreme Court said, no, that doesn't fly. And in 2017, they said it violates the free exercise clause for Missouri to apply its so-called Blaine Amendment to prevent religious schools from the government's playground resurfacing reimbursement scheme. So the state of Maine is up there doing the same doggone thing already in the face of a Supreme Court ruling that you can't do that. Because the Trinity case specifically said if you're going to give money to schools for playgrounds, you got to give it to everybody. Well, it's just remarkable that Maine was so hard-headed that they would fly right in the face of the case. What's even worse, in 2019, the Supreme Court held in the Espinoza case that the Trinity Lutheran doctrine held that the free exercise clause also prohibited Montana from applying its Blaine Amendment to exclude religious schools from a scholarship fund that provided state tax benefits to donors. So the state of Maine was basically telling the Supreme Court to take a hike because they'd already been ruled against twice, and so sure enough, the Supreme Court said, no, this isn't going to work. And they struck down the law. But I tell you that story because you can very easily run into situations in your own world where even though the United States Supreme Court has announced a rule or your circuit court has announced a rule, some local administrator either can't read, doesn't want to read, or just doesn't like you, and may be taking actions that violate your rights.
These are very precious dollars, and the programs have been going on for a while now, so I'm from the state of Maryland. And the legislature just passed some egregious language this past spring, summer, basically disqualified some of us from receiving funding language. And some of us got together and said, okay, we think it's okay. The state did that, we're going to take the funding because it had some language in there that quote protected us, but we got together with the ADF and some other Christian schools in there and said, no, the Supreme Court has already ruled on this.
3 times.
3 times. The state of Maryland is trying to do this. So we basically, with ADF's help, sent messages in to the Maryland State Department of Education and said, we don't agree with this. We don't think this is right. We're not going to participate in this program. We believe the Attorney General read the law and said, this is a waste of time. You guys cannot implement this law, and so we're waiting on that. But you know, my point is the states that are anti-funding, and it's really from what I understand, the teachers union in the state that's pushing the government to pull the funding back from the public schools. Is it's non-public schools. That's why we need our lawyers' help on this. Is to stand firm and push back, because we do have a Supreme Court.
Exactly right.
Whatever the state, it may be that I may not have gotten funds this year, and I had to figure it out. But you know, if we don't stand strong, the states are going to keep pushing on us.
That's a great point. By the way, is there anyone who is not familiar with ADF? I'll be glad to explain who it is or what if you don't know. So ADF stands for the Alliance Defending Freedom. It's an organization headquartered here in Scottsdale. It's got thousands of lawyers that are volunteers as well as paid staff. They have won something like 30 out of 30 cases before the United States Supreme Court defending Christian religious rights. And if you are aggrieved, and many of these cases, in fact, were either handled directly by attorneys for Alliance Defending Freedom, or they filed supporting briefs called an amicus brief in support of them. If you have an extra $10 million in your state you don't know what to do with, consider donating it to ADF, because it is a fabulous organization. They're extremely well run. They have top quality lawyers, and they really do a lot of good.
And if they take your case, it's pro bono. There is absolutely no cost on your part, other than your time and effort giving them the information they need. And so they have a formal process you go through for them to consider. But they will work with you. They'll send you some intermediate advice, so they'll answer some basic
Yeah,
questions.
they have staff attorneys. You can call them up and a lot of times we talk to them about those constitutional issues. And the other thing they do is they have a week-long educational course, which I've actually been through. They bring in constitutional law professors and attorneys that are handling these cases, and it's free for the attorney for a week. And then you have to do, I think it was 500 hours of pro bono work for them. Afterwards, I've actually done 1,000 hours, so I remember their honor court. I got a little certificate suitable for framing. Volunteer work for the ADF, but I'm a big believer in the ADF. There was another question.
These laws only apply for federal funds? No. What about local funds?
See, this was state law.
Yeah, my mistake.
I'm talking about local funds. I live in Concord. We have a church in Sedona.
Oh, what could possibly go wrong there?
Oh, yeah. Sedona gives funds to our preschool for our infant care room, but we can have no religious items in that room.
Nah, it's baloney. That's absolute baloney. And that's a good example. For those of you who don't know, Arizona is generally a pretty conservative state, although candidly a lot of people have been moving in from California, changing us from red to a little more purple. But Sedona is like the wacko capital of the world.
It's New Age haven.
It's just, yeah, I mean, they'll sell you crystals, and I was up there once about 15 years ago. People came from all over the world because they thought Bell Rock was going to levitate into space. Yeah, the vortex, yeah.
I think to get some legal help on that, because if you're running it on behalf of the state, then that's different.
Well, a city would be state action.
Yeah, or a city. I mean, there are.
We're running it as private.
Yeah, if you're running as private, that's one. But in Wisconsin, you can do it both two ways.
Yeah, see, so now if it's private for profit or private nonprofit?
We're not making any money.
Well, but are you a nonprofit corporation?
I gotta go back and check.
Yeah, you may want to, the devil's in the footnotes. So,
I guess you want to see, you said the devil's in the footnotes. You look at it from an administrator in the state, they sometimes are between a rock and a hard place. Because if they do some of these things, they'll be sued.
Oh,
On the
yeah.
other hand, they're giving funds to organizations like us. In Missouri, Churches and Early Childhood. Somebody else will sue them for giving us the funds.
Yeah, it's true.
They're really caught.
Yeah, it's true.
There's some animists, but there's some people who are caught in the middle.
Yeah, I probably skipped over too quickly an earlier phrase in which I said, there are sincerely held differences of opinions in the United States today about interpreting the Establishment Clause and the Free Exercise Clause. And if you don't believe me, Google one of these Supreme Court decisions and you'll see the incredible amount of information arguing for or against those decisions. And so, it's a contentious subject. And I would not like to try to administer one of those programs today.
It sounds like you follow it far more than I do, but my following of it, they're not all crazy ideas. In other words, in the sincerity aspect, to your point, some of what you read, you say, oh, well, I get where you're coming from. I don't agree with you, but I do get where you're coming from.
Whereas we tend to, in these situations, go to the absurd because it's far easier to make fun of it. And it's entertaining.
Oh, yeah.
I'm not being critical.
No, as long as we're all saluting the Lutheran flag, everything's happy,
Yeah.
right? But now let me ask you this question, because it's the ultimate test. I often have clients right before they fire me. Say now, so you're saying that it would be okay with you if the government Sedona, the city of Sedona, makes payments to a daycare center that promotes the Wiccanism and has chicken sacrifice at the end of the thing. Is that okay with you?
You're going exactly where I'm...
Because that's their religion, and according to what you just told me about the the free exercise clause, the government can't tell them how to run their church, right? The Church of the Dead Chicken.
If you're asking me, I think that their rights are protected as well.
That's
And then we as good Lutherans need to not hold back like good Germans and keep quiet, but actually engage and change people's hearts so that they fail, so that the Wiccans fail in the public domain. But if we try to use the Constitution against them, then they can use it against us.
That's exactly right. And I would say the irony of that in my world, I started out basically representing some small Christian churches 20-some years ago in building this church practice. Last year, about a third of our work was with the Buddhists, the Sikhs, and some Hindus. And because I have, following my training with the Alliance Defending Freedom, I've made it an explicit principle of my practice to assist any legitimate, bona fide religion in the pursuit of their religious activity without my evaluation of whether or not I happen to agree with them.
Doesn't that get you into trouble? You're making the judgment of who's really bona fide.
Well, you can't live in a world with no judgment. Even the United States Supreme, or even the Internal Revenue Service has a 13-point scale for evaluating what's a bona fide religion. So, for example, if you come in and say, hey, Bob, I want to start a church to, and literally we're going to sacrifice chickens and we're going to promote polygamy and we're going to promote some, being able to marry 10-year-olds. I'm sorry. You're not.
Be in Mormons.
Well, no, actually, that case closer to the reality than you might think. In Colorado City and Hillsdale, Utah, there is a sect of the Mormon Church, and I've done a lot of work on helping some Assemblies of God people go up there and try to undo that mess. I helped set up a food bank up there that delivers 50,000 pounds of food a month to help those people who were formerly victimized by that branch. And the legitimate Mormons don't want anything to do with them. They kicked them out of decades ago. It's a good point. Remember, the devil's in the footnotes. So can a coach pray with players on the field after a game at a public high school? What do you think? All those who think he can and shouldn't be fired, raise your hand. And those who think he should be fired, just keep your hand down. Oh, that's an HR person speaking right there.
I know you, so he didn't require it.
So this was the cases, Kennedy versus Bremerton, Coach Kennedy. Coach Kennedy gave thanks through prayer. By the way, these quotes are all from the Supreme Court decision. So I've excerpted parts from the record of the testimony that came in. He gave thanks through prayer on the playing field at the end of each game by taking a knee at the 50-yard line and praying quietly for approximately 30 seconds. That was the evil plot that Coach Kennedy was up to. At first, he prayed alone. But then some of his players asked if they could pray alongside him. And he said, and this is part of the record that came in the testimony, it's a free country, the coach says. You can do what you want. Soon, most of the team joined him, at least some of the games. But there was never a requirement that you had to pray or that you had to go there to be part of that operation. But if you wanted to, the coach wouldn't kick you out. So, Coach Kennedy, what do you think caused the lawsuit? How do we get from this guy praying out on the field to getting before the Supreme Court?
Somebody thought it was a study.
The practice had continued without issue for more than 7 years until an employee from another school actually made a positive comment about it to the superintendent at the school where the coach worked. He said, "Isn't that great that your coach prays with the kids?" And the superintendent had a cow. That's the coach. So the district quickly shut the prayers down. The coach was forbidden from, and this is the part which really helped him win in the Supreme Court. They wrote a policy which said he was prohibited from any, quote, overt actions that could appear to a reasonable observer to endorse prayer while he's on duty as a district paid coach. Now, let's just go ahead.
He specifically was forbidden, or was it policy for the entire school?
You're like, you've jumped a decade. You probably have a pronoun chart here. No, I don't know. That's me saying he. I don't know what the policy said, but I'm going to say it probably said employee. Okay, but even that, does anybody see a way that this is overreaching? What's an overt action?
And after the game, is he on duty as a coach?
Another good point.
Yes.
How about this? The coach goes to lunch and decides to bow his head and say, "Lord, thank you for this food." Is that an overt action? I think that one might have been overwritten a little bit. And the court specifically noted the directive would have prevented Coach Kennedy from even bowing his head and saying a short prayer before his meal in the school cafeteria. This is the kind of case lawyers love for Coach Kennedy, because the more ridiculous, the more overreaching, the more unreasonable the school districts are, the easier it is to skewer before the court. Free exercise clause comes back again. And here, the court ruled 6-3. 6 justices for, 3 against. The opinion was authored by Justice Gorsuch. Thank God for Gorsuch, a recent appointee under President Trump, that the policy was neither neutral nor generally applicable. Now, this is really important to understand because it didn't say that all overt actions of all kinds. It was basically saying you can't do anything that looks like you're promoting Christianity. That's what the policy said. That's not a neutral policy. Which, by contrast, if you're saying we're going to pave all the playgrounds in Missouri, that's neutral. But if we're saying only the Christian coaches can't pray, that violates the neutrality idea. Make sense? And it's not generally applicable.
In this case, did it specifically say coaching, or did it say all employees?
I don't remember that. I'd have to get the policy to look at that. But it was overwritten enough that it clearly made what he was doing. Yeah.
So if football players themselves decide, no problem.
Maybe. As long as it didn't look like somehow or other this was the school endorsing Christianity. With that superintendent, I bet you he'd have found a way to wash it.
State Bison, who've been national champions for 9 out of the last 11 years. 90% of the football team at home games gathered in midfield after the game and prayed.
Sure. And that's legal now under this decision.
I have one more little point. How long was this going on?
7 years.
And the superintendent never approved?
Yeah, no, you can't
Okay,
make this
never
stuff
mind.
up. You just, So, by its own admission, the district sought to restrict Coach Kennedy's actions, at least in part, because of their religious character. while permitting other staff after the game to visit with friends or take personal phone calls. So they were saying, your coaching duties are over now, game's over, it's your personal time. If you want to take personal phone calls, okay, you want to go talk to friends, but no, you can't go kneel in the field. That's the way it was written, and that just drove Gorsuch nuts. Well, with this we can't let this stay.
Given this is a public school, and why, just in your opinion, why do you think that they're going after the Christians so much, and yet they allow, in some public schools, and particularly places back home, they allow Muslims to leave the classes for their private prayer time and in private prayer rooms and cater to their dietary needs?
I don't know. I mean, it doesn't make that is not legal. You can't pick one religion and let them do stuff, or pick one religion and say you can't do stuff. Interestingly enough, many of the cases in the appellate courts, in the circuit courts, on religious freedom of exercise of religion have been Muslim cases, and Sikh cases like with beards and prayers, and one of them, a recent from last year, a Muslim prisoner objected to being strip searched by a female guard because that violated their religious principles, and this court said that's right, you got to get him a male guard. Then they tried to give him transgender. That didn't work. So the post-game supervisory requirement was not applied in an even-handed, across-the-board way. So that's the essence of the discrimination, if you will. Coach Kennedy's, the court, and this is important because if you have private speech, it's constitutionally protected. If you have government speech, you can't promote a religion, right? So they said, look, the coach's prayer was private speech. He was not speaking on behalf of the school. He was not speaking on behalf of the government. It wasn't government speech. So the district also violated his free speech rights. So that's like strike two. So the court used this case to affirm the right of public employees to engage in private prayer when they're not engaged in their work duties. So let me give you a kind of a hypothetical on that. Let's say you rock up to the State of Arizona driver's license division. You want to get your driver's license done, and you're standing there in line, and you hand in your money, and the clerk there says, "Brother, I would like to pray with you before I process your application, and I'm a Seventh-day Adventist," whatever they're pick one. Would that be legal? Why not?
He's acting as a state employee on state time.
There you go.
To provide state services.
Right.
Requiring a prayer.
That's right. And just like you wouldn't want to stand there and have to listen to a Wiccan prayer, an atheist shouldn't have to stand there and listen to a Presbyterian prayer.
And also the fact that the implication is if you don't pray with me, I won't process your...
Exactly right. Yeah, well done. Good point. Suzanne?
Which talked about which reasonably appeared, or which appeared to reasonably. I mean, in a world of trigger warnings, God only knows what people think about everything you do and for. Or did they not have to reach any of that?
I don't remember that in the case. I'm not saying it's not there, but it wasn't a major part of it.
Okay.
So I'm not going to spend a lot of time on this one, but for those of you who follow these things, in prior years you may have heard us talk about the Lemon Test. The Lemon Test was a 1971 Supreme Court ruling that denounced a three-factor test that the Supreme Court told the lower courts to use in trying to sort these questions out. And unfortunately, the government officials had figured out how to twist this test, and it was routinely used to deny Christian rights. There was a lot of discrimination against religious individuals and organizations that was argued as being protected under the Lemon Test. And the old Lemon Test had said that the government can help with religious activities, but only if the main reason they're helping is for a secular reason. So that one that caused problems. Then they said the government must be totally neutral about religion, and there must be no excessive entanglement, and that led down to a whole bunch of rabbit trails. So the court just said, we're not following limit test anymore. We're basically going to use a little more common sense. Is the coach speaking on behalf of the government, or is it private speech? And you don't have to go through all that three different things. So, why does this stuff matter to you guys? Well, let me give you an example of a case that's currently pending, and it's a high school case from the Brownsville High School. It's a music teacher. He was forced out of his job because of his religious belief. John, too, was forced to resign as an orchestra teacher because of his interpretation of the Bible. How'd this play out? 2017, the Brownsburg Community Corporation informed teachers that referring to a transgender student by their biological sex and not using the student's preferred pronoun would be treated as harassment and punished. Okay, so you could have what a biological female sitting there, and you could not call her her. And if she said, I want to be called him, the teachers have to call him him. Okay, you have to follow the student's wishes in the pronouns. This is a picture of the teacher there on the right, John Clute, former orchestra teacher. John believed this policy would harm transgender identifying students by denying the truth. He believed it would force Christian students and faculty to speak messages they did not agree with. So that's called compelled speech. He was being forced to speak against his religion by the government. Now, the superintendent, who met with John, claimed his beliefs, quote, aren't what's in the Bible. Now, John disagreed and cited a few verses saying, well, I think this is supported by the Bible, and here's why. The superintendent declared that his religious beliefs were wrong. John's attorneys at this point stood up, danced a little jig, cut out the violin, and ordered the champagne. Because this superintendent not only was wrong, but he was an idiot. Because he is openly saying, you can't practice that way. And is that establishment of free exercise? Exercise, exactly right. Clear violation of John's ability to freely exercise his faith. So this thing goes, the thing you see about these cases is they tend to drag out for years. And this thing was painful. So they argue back and forth and this and that. And finally, they give him a religious accommodation in which he agrees that he will call the students by their last names. Like a coach. And the coaches on the football team, they don't call you Bob or Sam or what. They just say, Brown, get out there. Right? So the orchestra guy says, hey, if the coach could call the quarterback Brown, I'm going to call the piccolo player Brown, and then I don't have to worry about pronouns. Fair enough? Okay, so they all say, all right, well, that'll work for a while. Obviously, you can imagine the superintendent wasn't really happy with it, but he went along with it for a while. They come back again and they re-announce the policy in 2018. Say, sorry, if you don't call them by the pronoun, it's harassment and you're going to be fired. They went back on their accord. So at the end of the year, they fired John because he wouldn't do it. He said, I'll call the piccolo player Brown, but I won't call him her. Too bad, you're fired. Wrong religion. You're misinterpreting the Bible, blah, blah. Well, here's the quick timeline. 2018, John was forced to resign from his position as an orchestra teacher at the high school. In 2019, a lawsuit was filed. In 2021, the federal district court ruled in favor of the district court, which if you think about that one for a minute, you think, how in the world did the district court get over that testimony by the superintendent? But they did. In October of 21, it was appealed to the 7th Circuit Court of Appeals. And in January of 2022, the 7th Circuit heard an oral argument. It's still pending. We don't know what's happening on that one.
13 months?
Yeah, so it's just bizarre. There's no rule that says how long they can take.
Curiosity is the worst.
He was virtually fired.
Somebody just had fired me, because I was just dealing with,
Right. And if you voluntarily resign.
It doesn't do any harm.
Right.
The courts don't care as much about it, but if they do harm, then the courts care more about it.
Yeah, I don't know the nuance on that one. I agree with you, that's normally the way that plays. Part of the reason I brought this up is to show you, unfortunately, the awful, gut-wrenching, tedious, grinding nature of these cases. They go on for years, and they are upsetting your family, they're upsetting your job, your career, and that's why these rights are so important. But it also shows why it's so important for somebody to stand up and right these wrongs, even though it's not easy to do.
Yeah, I want to go back to the last one, I thought you might bring it up. Some of the arguments in this case got to what the coach was thinking. He was trained privately, and the outcome of this discussion is the people against the coach will say that he's going to discriminate between players on the field
Yeah.
based on how he thinks.
And that's the implied government
His
action.
actions
Yeah.
never show that. His actions never show that whoever showed up for prayer, they never got more or less there. So his actions never showed that. But they were saying that, but his thinking, and so I think we're getting into the point where, our what's in our mind, not what we do, can be litigated against.
And why that's actually, in some sense, a legitimate argument, because if your thought gets converted into government action, so if the coach, as a representative of the school, is favoring the Christians as quarterback, that's not legal.
Right.
But if you just think you like the guy better, that's all right. You're other things. So here's, before we move on, any other comments or questions?
I just want to make it, this is a case that obviously is going on really long.
Yeah.
But I live in San Diego, and I would say, don't be discouraged. Awaken Church now has been attacked by the city of San Diego twice. One for not obeying health restrictions of shutting down the church. And they said, we're not going to shut down our church. And they worshiped, thousands of people weekly. They took that to court and won. Here this past, in December, they rented the Rady Shell, which is the largest outdoor amphitheater to have this massive Christmas party. It seats 10,000 people. Had the contract signed. A month before the event, the City of San Diego, the council says, we're withdrawing it from you. You can't have it because we don't like what you believe and what you promulgate.
Thank you.
And they canceled the contract. And they had literally 10,000 people showing up. They hired Kelly Shackelford and said, hey, this is fantastic. You're going to actually build 2 or 3 more churches for them when we get done with you. And they graciously said, here it is. What else can we do for you? What can we provide? So if you act on it, some of this stuff will be really quick.
Yeah, and that's why ADF is so important, because they will help you write letters,
Yep.
for example, and they'll tell you how to write them, what to call, how to build that record.
But even in California, we've seen amazing, if people stand up and aggressively pursue something, you want to get on it and don't allow them to, I mean, it's just intimidation.
It is, no question, yeah. We see this, churches will occasionally run into this too for building permits, special use permits and so forth, and there is a law beyond the course of our study today, the Religious and Institutionalized Persons Act, RUPALA, and it basically says you can't discriminate against a church just because they're a church, because candidly, a lot of the city councils would love to convert that church into tax-paying property. So they're looking for excuses to shut them down. In Scottsdale, we had a major church. They got into a problem just because they wanted to add an awning. So they had to get a building permit for it, and the city tried to argue that therefore they lost their grandfather clause that had allowed them to operate there under special use permit. Yeah, it's amazing. So the rest of the story stuff. This is, to me, this is kind of a poignant part of the class. I'm an Eagle Scout. I love the Boy Scouts, and my heart was broken over this whole episode in more ways than one. This is an ad that back when all this was starting to come out, a plaintiff's attorney was advertising for people who thought they were abused 40 years later, whose memories now had been awakened, to come sue the Boy Scouts. So a wave of lawsuits, and I'm not defending what the Scouts did. There were clearly some bad actors in the Scouts. I think in a way the Scout management was reflective of our culture at that time, because let's face it, the Catholic Church, you can name many major institutions in the 50s, 60s, 70s. They just weren't aware of these things. They weren't tuned into them. And the Scouts were a bad example of that lack of being aware of this issue. So they filed for bankruptcy in February of 2020. They paid out $850 million to 70,000 individuals who successfully brought claims. Now, the reason I bring it up here is if you have a church that has a charter with the Boy Scouts, or may be approached about having a charter with the Scouts or a similar organization, because they're no longer the Boy Scouts, they're just the Scouts. But the questions that you have to look for, especially if it's a Boy Scout or an old Boy Scout organization, the bankruptcy wipes out any liability of the national organization under indemnity claims or under direct claims. Let me just quickly give you some insight into this concept of indemnity. So indemnity is when somebody else that you're dealing with does something wrong that you are held liable for. It's called secondary liability. So it's a good example is if Fran is working for her church and she drives the church van and runs over the brain surgeon in the crosswalk, clearly Fran is the one who has primary liability, right? Because she was driving. But because she's an agent of the church is also liable under secondary liability. So the church could have, in some circumstances, an indemnity agreement requiring Fran to pay it back for all the damage she caused to the church. Now, and in the Scout situation, that was where, in your charter agreement, there was a clause in there which said that if the Scouts had a problem that caused the church to be sued, then the Scouts would provide insurance and would indemnify the church, right? So that's a contractual obligation, and the bankruptcy for any event which occurred prior to the date of filing the Chapter 11 is wiped out. There is no more liability. And so that means you have no right now to go back to the Boy Scouts for an event that occurred prior to that bankruptcy and get indemnity.
Your example, Fran, wouldn't the church be secondary because she's driving their van, not because she's employed?
Agent. The legal principle underneath it is called agent, principal, and agency.
But isn't she an agent 24 hours a day if you're employed?
Not necessarily. For example, if you're at home, you're not, and you blow up your house because you're cooking meth while she's doing at work or on church business. Yeah, we have a case like that now where the person that was in charge of the Vacation Bible School had some kids helping them set up, and then they went to pick up lunch. So they're out picking up lunch. Well, is picking up lunch part of the duty so that it's covered, or is it that private act? So it's a good question, and there are issues that we played about this. In this case, picking up the pizza was part of the duty because these were all volunteers and they were getting fed, they were going back.
Distinction between driving the church van and driving the personal vehicle onto church business.
Both can result in liability to the church under principal agency. And the high-level concept is when you have a person that you have hired or authorized is really the key word to act on your behalf, then they are acting on your behalf when they do something good or when they do something bad.
Right. I'm allowed to personalize our situation.
Well, let me ask you, if it's a war story, I'll buy you a cup of coffee afterwards, and we'll have.
I know.
Okay, I'll come afterwards. We'll do it. Because I got 42 more slides, and I've only got 12 minutes. That's all right. We're not going to get all of it. So anyway, the bankruptcy filing And by the way, the theory of bankruptcy is when you have a bankruptcy filing, we basically say all of the debts of the person that filed prior to the date of filing are erased. But you can bring those debts into bankruptcy court and we'll deal with them. And in the case of the Chapter 11, that meant that under the bankruptcy judge or the trustee, all the Boy Scouts' assets are brought in and handed out to all of the debtors. And the whole point of bankruptcy is to consolidate all the debts and all the resources in one proceeding, which is why you can't go sue them in state court. Does that make sense? So that means in our case, if you didn't know about it, didn't do it, too bad. You missed the filing. So the other question is there, even if you have something like that pop up, there might still be coverage under the insurance policy you had with the Boy Scouts if the Boy Scouts named your church as an additional insured. So when you're reading these charter agreements or when you're letting somebody else use your facility, the two things you've got to look at are the indemnity clause, which will make them contractually obligated to cover you, and number two, getting your name on their insurance policy. So that now you have a contractual relationship with the insurance company, so that even if they go bankrupt, you still have insurance coverage. So if you run into that, definitely seek counsel. All may not be lost, because there still might be insurance. Also, you still may have your own church insurance to protect you if something like that were to come up. Major takeaway, if you had any Boy Scout activity in your church, when you apply for new general liability insurance, be sure you disclose that on your application. Because many of the policies are what are called claims made, and that means the insurance company will cover claims if they're made in the year of the policies in effect. So let's say in 2023, even though the event occurred in 1982. So you want to make sure you make a full disclosure so the insurance company can't go back and say, you didn't tell us that. The Boy Scouts were not going to cover that. Let's see, that's enough for Boy Scouts.
So the claims made does go back to 1982 if you disclose it?
It can. I'm not going to say that it does. I'll say that it might.
We're talking about legal law.
Footnotes. We're down in the devil's department. So I love this one. This one's from like 1907 Scouting, Be Prepared, How to Light a Match, and other 199 other useful things to know, like light a match to that charter agreement. So the takeaways were: note the difference between indemnity protection and being a named insured. Read the charter or other agreement carefully, and think about how the risks are being allocated, because that's the important point of many of these documents. Follow up on Jack Phillips, the cupcake, before the cupcakes, he was a cake baker. Some of you may have followed his original deal, which was just a horrible case. The Colorado Civil Rights Commission was one of the most biased groups. They qualify right up there with the Salem witch trials. They were bad. And the Supreme Court slapped him down 7-2. Jack had refused to design a custom wedding cake for a same-sex couple based on his religious belief, and the United States Supreme Court, overruled all the other courts. He lost in the Civil Rights Commission, he lost in the state court, he lost in the district court, he lost everywhere until the Supreme Court said no, that he was within his First Amendment guarantee of religious exercise. His belief was sincerely held, and he couldn't be compelled to make
In these cases where somebody literally, their life is ruined for 3 or 4 years because of the case, do they have the ability to get funding back?
Not much.
It's just like we're just going to ruin your life for 4 years.
Yeah,
right?
pretty much.
Yeah.
Yeah. Here's the amazing part about this story. So Jack now is involved in part 3 of the series of lawsuits. The first case was won in 2018, so Jack stopped doing wedding cakes. He said, I've had all this, I can take ADF, defended him, by the way, and for free, but still, it hurt his business, obviously. So now, the day that they heard about winning, a lesbian attorney called his cake shop, asking him to create a pink cake on the inside with blue icing on the outside. Okay? Anybody guess where this one's going? Colorado attorney Autumn Scardinia sued Phillips after her request for a gender transition cake was rejected. Now, I want to point out something here. Jack, I've met Jack. He's a really decent guy. And he will tell you, and the record reflects, that if a gay couple or a lesbian couple or a you name it couple, a Wiccan couple comes in and says, I want that cake up there on the shelf, he'll sell it to them in a heartbeat. Not a problem. He does not, he'll hire gay people or lesbian people, doesn't care. But he's a custom cake maker. He is an artist, and if he said, if you come and say, I want you to do my wedding cake, he will meet with you, he will meet with your betrothed, and he'll say what are your favorite colors, and he'll get pictures, and this cake will be custom to you and your personality. And he said, I'm not doing that. He won't do Halloween cakes either, because they violate his view of biblical imperative. So this third one, this person comes in, the transgender lawyer sued Jack for refusing to make a cake to celebrate the transition into a different sex. Jack lost in the trial court in Colorado. He lost his appeal to the Colorado Court of Appeals on January 26th. And Jack Phillips now, it was just announced last month in January, they're appealing the decision withheld from the Lions Committee preview. Put Jack on your prayer list. This guy has been through hell.
Question. If this person had walked into a shop, didn't announce who she was, and just said, I want a cake with blue.
He probably made it. Because the colors themselves.
Right.
But it was the fact that he's being asked to endorse a message, which compelled speech means the government now is forcing him to make a cake as part of an artistic expression in celebration of a lesbian transition or a transgender.
But the fact that she explained what she wanted, why she wanted it, elicited an action from him.
It turns it into compelled speech.
Now, doesn't he have a choice to say, okay, I'm going to take your word for what you want this cake for, which is against what I believe, so I'm going to do it. Or he could say, you're a nutball, and I'll make the cake for you, and it's not what I believe. But you believe whatever you want to believe. Take the cake and leave me alone. Could have done that.
I suppose, yeah.
I mean, it's sort of like in Corinthians, with the Christians facing meat that was sold and had been sacrificed to idols. Well, if you want to make a deal out of it, then that's the direction you're going to go. Or, as Paul says, it's nothing.
Yeah. Many ways to skin the proverbial cat. So Phillips says the cakes he makes, custom cakes, are a form of free speech, and he's appealed the ruling. There's a link to the Alliance Defending Freedom. If you want more details on this, it's a great place. Just you can Google ADF legal Jack Phillips, and it'll take you to the latest news on it. Here's a case, another ADF case. I actually worked on this case, and I know Baronelle. That's Baronelle Stutzman. She ran a florist shop in the state of Washington. She hired a gay staff, and in fact, one of the members of her staff, a gay guy, had worked for her for years. And he got engaged to a gay person after the gay marriage thing came out, and they asked Baronelle to make the flowers for their wedding. She gave her employee a hug and said, I love you, I'd be happy to work for you, but I can't participate in a gay wedding. The guy himself said, yeah, I understand. Baronelle, boyfriend wasn't hearing of it. So he posted on the internet, somebody in the Washington Attorney General's office picked it up off the internet and filed a civil rights discrimination case against Karen. The case went on forever. It went through multiple iterations, finally winning in the United States Supreme Court. But the Supreme Court's ruling sent it back to the state of Washington for another trial, where she lost in the trial court again, and then under the new rules that were announced under the interpretation of Washington's discrimination law, lost in the Washington State Court. She was essentially forced to retire. She was, gosh, at the time she had to be close to 70. And so ADF helped her negotiate a settlement. She paid $5,000 to the plaintiff in damages, but didn't have to pay any legal fees, and closed her business.
We should go back to the football coach case. He doesn't have to stop that.
Is that right? I didn't know that. I didn't.
Because there's some, even though he won the case,
Yeah.
the school did not have to reinstate.
Interesting. Yeah, these things are not without cost, but Christ warned us. So here's late breaking news. This one's a little more positive. After all that news, I thought, geez, I better be depressed on Saturday morning. Better find something a little happier. So this is a little happy news. This is the late breaking news as of February 13th. The case is Soule versus the Connecticut Association of Schools, and this is a girls' track team. There's a case pending before the Second Circuit Court of Appeals. Will now changed its mind after ruling against the girls, has now changed its mind and is allowing the full court. And rabbit trail here. Many times when you have a case that goes first to a court of appeals, they will have a 3-judge panel that hears the case. But these circuits have as many as 10 or 11 judges in them, so the number can vary. But if it's a really important case, they'll have the entire group of judges hear it. So the 3-judge panel at the Second Circuit ruled against the girls. They appealed that, and the court came back and is now scheduling a hearing in the future for the entire set of judges to rehear the case. And it's a legal challenge to Connecticut's interscholastic athletic conference policy that allows males who identify as female to compete as females. There are 18 states that have laws protecting women and girls from having to compete against biologic males. A majority of Americans, when polled, agree that the competition is not fair when a biological male is allowed to compete in women's sports. So the facts of this specific case, 2 biological males who identified as girls had won 15 state women's titles, had secured 85 spots in next-level competition, and broke 17 records that would otherwise have gone to biologically female athletes. Anybody getting the idea that maybe the guys are having a little bit of a genetic advantage?
I wonder, has any of this kind of spilled over to the NCAA level of sporting? Because I mean, that's where the big money is, right? I mean,
this whole thing this whole area is in turmoil. Yeah, I mean, the fact that a 3-judge panel wasn't good enough, now they're going to have the 9-judge panel, and it'll probably end up before the Supreme Court, and probably, as you can see, it's already ended up in many state legislatures. Some have gone one way, some have gone the other. The country doesn't know what to do with this.
It's international track.
Oh, yeah, of course. Yeah. So in this particular case, Chelsea Mitchell, who is represented in the lawsuit, placed second in 4 state championship events behind a biological male, and placed behind a biological male 20 times. So she just couldn't beat these guys. Their musculature was just the one fair fight. Why do I care? Well, that's my granddaughter, Mackenzie, giving her first salute to my son Kevin, who was just sworn in as a lieutenant colonel in the Marine Corps. And so I'm trying to keep Kevin from shooting the people who are going to take unfair advantage of Mackenzie. So pray for Mackenzie, me, and Kevin. Suzanne's laughing because Kevin also now has retired from the Marines as a lieutenant colonel and works for her old law firm, Snell and Wilder. So we've got a few minutes left. We can either take questions, or if you want, I have a series of kind of what I would say are practical takeaways on this. I'll be happy to run through a few of them if you like, or we can call it early. I know you guys have a lot of sessions.
Well, I'm going to suggest a question.
Sure.
I'm in the middle of rewriting and updating our employee manual, and the attorney has suggested lots of non-discrimination language, which is boilerplate. But now, when you get into the discrimination sections, there's gender language. And how do you propose dealing with that? We're not going to hire a transgender teacher.
Okay. Well, you are a Christian nonprofit organization. Correct. Okay. So the interesting point, that's really a very good question, very timely. And in the Ninth Circuit, which is California, and it's pretty good law in many of the circuits, but not necessarily all. It's called Spencer versus, it'll come to me in a minute. It's referred to as the Spencer case, but it basically says, if you have a statement of faith, you may require people to sign and agree with your statement of faith, or they can't work for you. And if they violate that statement of faith, you can fire them. Okay, so what we're saying here is, look, and I do think there's some social wisdom to this too, because let's be fair. There have been some very sad cases involving the gay community, the lesbian community, the transgender community. These people have been bullied. Some of them have been seriously discriminated against in unfair ways. So I don't want to come across as saying, well, look, I am not anti-anybody. I am pro-Constitution. And I am definitely in favor of freedom of religion, which says, and must say, you must have the freedom to worship with only the people who agree with you, to have any freedom of religion at all. So your statement of faith can say, those who are going to work in your church or work in your Christian school must agree with your statement of faith. So the point is, you're not hiring somebody because they're a Wiccan or a gay or a lesbian or anything. You're signing it because they won't agree with your statement of faith. And that's where we're on very solid legal ground. So you drive it back to the Scripture, you build it into your statement of faith, and you say, and you enforce it uniformly.
We just did a similar, we're kind of going through the same thing, and everything that I've read is you need to make sure it's very clear in your employee handbook what that statement of faith is. And the scripture background really, or the scripture references really helps to codify that you're not just discriminating, but this is what we believe, and everyone has to abide by that.
Can that be applied relative to the other question I might ask is, guiding marriage ceremonies to people in our churches, and how do we protect our churches relative to?
You're safe. I wouldn't lose a wink of sleep over marriage. Because as long as you drill it back to what she was just saying, to the Scripture and to your interpretation of the Scripture, and have a clear policy of it. And not a court in the land that's going to force a pastor to marry, to have a Muslim marry a Jew.
Right.
The Jew's not going to be able to go get the Ayatollah to marry. That's not going to happen.
For security purposes, though, you're suggesting, I believe, that you need some kind of statement of faith relative to performing ceremonies.
Yes.
Have a marriage policy.
You can even go further than that. If you're hiring, let's say, a teacher in your staff, and you disagree with them living with another person, put that in your policy as well.
That was the Spencer case, in fact.
Yeah, it's just like, I mean, you just put all of your beliefs. It's not just about transgender and that type of stuff. It's like what you find acceptable and unacceptable. Your pastor, you don't want him dating when he's married. You need to stipulate that's something that's going to cause a major problem.
Well, the problem, I don't see a problem with pastors and teachers and aides, but it comes down to, what about the custodian or the cafeteria? And Our view is that you have to express Christian living at all times, consistent with our beliefs.
Well, there you have the Hobby Lobby case, and that one is a good one to go back and reread. Well, a lot of the discussions that you read about will tend to be focused on the ministerial exception for employees. You have clear grounds for protecting your ministerial employees. So anybody who is involved in transmitting the gospel, teaching the gospel, leading religion, all that, you're bulletproof on those because nobody's going to force the Jews to hire a Muslims only, right? So, but when you get down into some of those lower positions, then you've got to go back to a whole lifestyle thing like he's talking about, and then take a look at the Hobby Lobby case. You want to work things like mandatory prayer, attend prayer meetings. They have to have mandatory Bible study. They have to sign the statement of faith.
Is there kind of an equal requirement you put there for volunteers versus employees?
Yes, although I will tell you, just based on the practical experience I hear back from my church clients, it's a giant can of worms. Everybody's already short of volunteers, and now they're trying to have a different set of, are you going to have the same criteria, less criteria, who's going to enforce the criteria?
For example, the church, our statement of faith includes affirming, biological gender for those things. Then we have a school, and we have parents who aren't members of a church who want to volunteer in the school.
Yeah, the one useful distinction is whether or not they have any kind of leadership or teaching position. So I would say one group I know of applies that test to head coach of the soccer team. You can be a parent and bring the snacks, but you can't be the coach. And with buy-in of those volunteer criteria. That's not that I've read much. Everybody was pretty worried about it, but I actually haven't seen any cases come out yet.
But it's early.
Amen, brother. I feel like the liberal agenda is the Attorney's Full Employment Act. So a couple of those sort of practical tips that fall into this whole area. One of the keys is communication. So if you really have these sincerely held beliefs and they're clearly set forth in your statement of faith, it's really worthwhile to have a senior pastor type person or your HR person who knows what they're doing, who's been trained in this, to meet with the employees and take them through the HR requirements in the statement of faith and have them initial them. So that literally, when I take your deposition 2 years later, you can say, yeah, I have it here in my calendar. I met with Fran on July 1st. She initialed the statement of faith. She said she would never live with her boyfriend outside of marriage. And as was the case in that Spencer case, they just changed their mind 2 years later and moved in with each other and got fired. And the Ninth Circuit upheld it. Too bad. You signed it.
We do this on an annual basis when they do reviews. So when they do their performance reviews, I've asked everyone to go through their job description to make sure that what they're doing is accurate, and that if there are any, because I go to church, for example, I go to church at a Lutheran church, but I work at a Free church. My job description gives me a clause, an exception to not worship and not be a member of the church that I work at. So if you have anything special like that in a job description, you acknowledge it once a year, and then we also have them acknowledge the handbook and the statement of faith that is in the handbook once a year as well. And that way we're making sure that nothing's slipping through the cracks.
Best practice for sure.
And that a janitor, that he understands what's expected of him, and so he can't come back and say, well, wait a minute, I didn't know I had to be a member here.
By the way, it's Spencer versus World Vision.
Included our statement of faith in our application, so you can't even apply without understanding there's additional things that are required from you. And then it's the first question we ask when we send the first interview with you. Did you read that? Do you have questions on that? If you don't, okay, let's set a time for us to interview. Because we did get burned about 3 years ago with someone who just signed paperwork, okay, didn't read it, and then found out he was getting married to a woman. Had a conversation about it, we decided that was discrimination and caused a whole bunch of problems.
Another way to do it is to put, if you advertise for jobs, before you can look at the jobs, you have to look at the statement of faith and click the box that says, I read the statement of faith, but don't make it 90 pages long. You know, if it's like 1 page or something, then, because the jury's going to look and say, well, did they really read it? Was it reasonable to read it? But yeah, there's endless variations of this theme. Guys, we are at about 2 minutes left. We got maybe one more question.
Can I put a plug in for Christian conciliation clauses?
Yes, please do.
Yeah, so I encourage you, for all of these sorts of agreements, Christian conciliation clause, which essentially says we are Christians, and rather than go to court, we agree in advance to submit this to Christian mediation and or arbitration through the Institute of Christian Conciliation. So that keeps it out of the court. So
Yeah, at least in Arizona, those clauses are enforceable. You have a clause that says this is the exclusive jurisdiction for resolution of all disputes arising from our contract, is through this process with a person who's had training from the ICC in mediation, as well as who's on their approved list, and that their dispute will be resolved in accordance with scriptural principles. And it's fabulous, because you do not know what you're going to draw for a judge when you go down to Maricopa County Superior Court, and many of them will not share your faith.
So I've got a couple of handouts left, but I've got one I want to give you.
Okay, I'm a huge, but I include this in every contract that my clients will have.
How widespread regionally are you?
We have conciliators worldwide.
Okay. That's pretty widespread.
That's pretty widespread.
Yeah, they're working on Mars. Guys, thank you. You've been a great audience. I really appreciate your involvement and questions and comments. Thank you.